Well, while Jennifer is pulling up the slide, I am Carlton Coleman, the section manager for the Public Guardianship Office, and she was correct. I have 24 and a half years, and not a spring chicken, but a chicken that's looking at getting out in another 3 years with my full 30. I want to tell you a little about the Public Guardianship Office this afternoon because the work that we do is very critical to the Division of Aging Services and the Department of Human Services as a whole. Jennifer, you may have to move my slides for me, so if we could go to slide 2.
Yes.
To start off with my presentation this afternoon, I just wanted to share with you and remind you that the vision for the Department of Human Services, Stronger Families for a Stronger Georgia. And the vision and mission statement for DAS, next slide, Jennifer, is living longer, living safely, and living well. And our mission is the Georgia Department of Human Services, Division of Aging Services, support the larger goals of DHS by assisting older individuals, at-risk adults, persons with disabilities, and their families and caregivers to achieve safe, healthy, independent, and self-reliant lives. And that's pretty much in line with the work that the Public Guardianship Office does. So to tell you exactly what Public Guardianship Office is, the Public Guardianship Office, of which we all call ourselves as PGO, is of the Division of Aging Services and is assigned the oversight and delivery of guardianship cases on behalf of the Department of Human Services. Now, we don't just go out and get our cases. If you don't remember anything else from my presentation, just remember this. Public Guardianship Office, also known as PGO, is separate from Adult Protective Services, also known as APS. We are two separate programs. APS can receive a referral to go out and investigate, and if the need be, APS can file a petition for guardianship. PGO cannot do that. PGO only gets the cases from the court, and that is when a person, which if Jennifer goes to my next slide, when a person has had a referral or petition made through the probate courts of Georgia, and the guardianship is determined through that court that that person who is the subject of that petition needs assistance with making the decisions due to their lack of capacity about his or her safety. Now today, to make it interesting, I've sat doing Allison's presentation and picked out some names so we could walk through a scenario to better understand guardianship. Next slide, Jennifer. All right, so for today, as Jennifer stated, I'm going to age Jennifer about 30 years. And if you all notice, while Allison was presenting, Jennifer's camera was still up. So we all realized during Allison's presentation that Jennifer has a problem with drinking. On top of that, Jennifer also has had a diagnosis of which she is keeping a secret of Alzheimer's and dementia. Well, Ashley Burton, who is on this call as a participant, is Jennifer's sister. Ashley has been trying to work with Jennifer to get Jennifer help, and Jennifer is refusing. Tangela Gray, who is also on this call, is Jennifer's neighbor. Tangela and Ashley keeps in touch with each other regarding Jennifer's behavior because Jennifer, she's been aged by 30 years and she lives alone. So Ashley is concerned. She shared her concern about Jennifer living alone and her condition with Tangela, and Tangela tries to keep an eye out on Jennifer. So over the weekend, Jennifer just did some bizarre behavior which really, really concerned Tangela. Tangela put in a call to Ashley. Ashley decided to say, okay, I need to go the route of trying to get her some help. Jennifer saying, I'm grown, you can't tell me anything. You may be my older sister, but I'm still going to do exactly what I want to do. Ashley is saying, but I need to get her some help. So Ashley knows about the process for guardianship. So the first thing that Ashley is going to do is file a petition, and that is pretty much the paperwork which lists specific facts as to why that person needs a guardian. And that petition is a form packet. Once complete, is submitted to the court. Now, Ashley can do one of two things. Ashley can serve as the first petitioner and go to Jennifer's doctor. And the doctor, if willing, can sign and complete an affidavit indicating, yes, Jennifer needs a guardian. Ashley can take that affidavit and submit it with her petition to the court. But in this case, Ashley doesn't know anything about Jennifer's doctors because Jennifer has been, what I've just reviewed today in a personal status report, she's been doctor hopping. So Ashley is going to fall back on Tangela. The second scenario is that Ashley serves as the first petitioner, Tangela serves as the second petitioner. Once they've completed, signed, has the petition notarized, that petition goes into the court. Well, it's their lucky day because today we have Judge Tamara Cantrell, who is going to be the judge over this entire process. The evaluation, well, the petition is submitted, the judge accepts it, the judge sets it up for an evaluation, and that is a court-ordered evaluation that has to be complete on the person in need of the guardianship. So in this case, Jennifer has to go before a psychiatrist or a medical doctor to complete an evaluation. The Judge Cantrell is also going to set up for Jennifer to have a court-appointed attorney. And today, Jennifer's court-appointed attorney is Sandy Coker, which Sandy is going to represent Jennifer well. Even though Sandy may feel after meeting with Jennifer that Jennifer does indeed need a guardian, Sandy is going to go in there and advocate on behalf of her client. But that does not help the court make a decision. So Judge Cantrell is also going to appoint a guardian ad litem, which is going to be a neutral individual to reach out and talk to all parties involved. That individual is going to talk with Tangela. That individual is going to talk with Jennifer. That individual is also going to talk with Jennifer's sister, Ashley. And today, our individual who is a court-appointed guardian ad litem is Alexis Jefferson. So all this is taking place. Sandy has met with Jennifer, knows that she's going to the hearing and she's going to advocate for Jennifer. Alexis met with Jennifer, is going to file a report back to the court. So we're now at the hearing. At that hearing, we know that Jennifer is going to contest because Sandy has to advocate. So Jennifer's appearance was not waived, so Jennifer is there. The Judge Cantrell is going to hear testimony from Ashley. Judge Cantrell is going to hear testimony from Tangela. Judge Cantrell is also going to hear Jennifer, and Judge Cantrell is also going to hear the presentation from Alexis. If Jennifer brings any witnesses, the court will also hear that testimony. After hearing all testimony, after that point, the judge is going to close it where any more testimony can be provided and make a decision. If Judge Cantrell determines that, yes, Jennifer is in need of a guardian, she will make that determination based off of the code 29-4, which will be the order of preference. Now, Ashley is the sister. Ashley can have the option of serving as Jennifer's guardian. Tangela is the neighbor. Tangela can have the option of serving as Jennifer's guardian. But because Jennifer's behavior is so bad, no one wants to serve as the guardian. Or, Ashley could have said, okay, I'm willing to serve as my sister's guardian, but Jennifer could object and say, well, if I have to have a guardian, I do not want my sister to serve. If Tangela is willing to serve as the guardian, Jennifer can object and say, she's my neighbor, but she's nosy and she stays in my business. Absolutely not. I do not want her to serve. Well, the judge has to appoint someone. If no one is willing, or individuals are willing, or there is someone there is contesting it, such as who will be appointed, like in Jennifer's case, then the court will appoint the department as guardian of last resort. Now, there are several types of appointments. There can be an emergency appointment. There can be a permanent appointment. There can be a temporary substitute appointment. Emergency appointment only lasts for 60 days. A permanent appointment lasts for the life of the client or until someone else comes forward and say that they are willing to serve as a successor guardian or the client has their rights restored. A temporary substitute is only good for 120 days, and that usually occurs when someone else is appointed guardian, but for some reason, that individual has not been carrying out their fiduciary duties to ensure that the person is cared for, or in most cases, we get appointed temporary substitute because the person that was appointed the guardian fails to submit a personal status report, which has to be submitted to the court on an annual basis, which is, if you can look at this, this is a stack that I'm reviewing now for about a total of 78 that we have to submit for this month. If that individual fails to submit that report in a timely manner, then the court can temporarily remove that individual as the guardian, appoint a temporary substitute guardian, which, is, like I said, is only good for 120 days, and will set a hearing for that individual to come before the court and explain why they did not do something. At that hearing, the court can either reinstate that individual or remove that individual permanently and appoint a successor guardian. There's one more that we rarely ever get. I think since 2011, since I've been working with guardianship, we've only had it twice, and that is known as a limited guardianship. I actually hate those because we primarily get appointed as guardian, but in both scenarios, the individual maintain their rights to make their medical decisions, and it's hard for us to know what's going on. And if the guardian asks that individual, well, do you have any medical appointments? Are you taking any medical medications? My personal experience with it, the client looked at me square face on and told me, I know my rights. I can make my own medical decisions. You do not have to ask me about my medical appointments or what medications I'm taking because I manage that. We're in a hard place to know exactly what's going on with that client in order to be able to help them. Next slide, Jennifer. So we now have Jennifer as a guardian. That case will be assigned to a case manager, and that case will be assigned once the oath has been taken and the department has received letters of guardianship naming the department as the guardian. Now, notice I said letters of guardianship naming the department. I get a lot of calls every day where the department has been appointed the guardian, and they immediately say, I'm calling because you are the guardian. And I have to go back and re-educate and say, no, I'm not the guardian. It was like yesterday I was traveling to court and I got a phone call saying, well, I need to talk to you in regards to this client, blah, 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 blah. And I had to stop the lady and say, first of all, I don't even know who you're referring to. And she said, well, I have your name listed in your contact information. I was told that you're the guardian. And I had to tell her, no, the Department of Human Services is the guardian. You may have been given my name because I'm listed as the section manager for the program. And that usually is what happens. The courts give my name and contact information because I'm the primary point of contact that they see when we get appointed. But I was able to, since I'm mobile with two phones in the car, I was able to put that person on hold and call on my other phone to the office and say, hey, can you give me the name of the case manager and give me the case manager's contact information? And I was able to get that taken care of. But we all have, for the program, we have 42 case managers statewide. We have 5 supervisors, 1 district manager, 2 generalists, a program associate, and myself, who manages the entire state. In Jennifer's case, we're going to put Judge Cantrell down in South Georgia. So we assign the case. We know that we're the guardian of last resort. The case manager will act as Jennifer's surrogate decision maker, will also act as her advocate advocate, and coordinate and monitor services. Once that case is assigned, the case manager has to meet with Jennifer. Next slide, Jennifer. All right. In order to make those circuit decisions for Jennifer, we have to know a little about Jennifer. So Jennifer may have Alzheimer's, dementia. We still have to get as much information from her, and that includes reaching out to her sister Ashley, who knows more about her. We try to involve Jennifer to the most extent possible to make sure that we're making the right decisions. If Jennifer just says, I do not want to leave my home, we try to make it possible for Jennifer to stay at that home, because as the guardian, we are responsible for ensuring that we place the individuals under the state's care in the most least restricted placement possible. So we have to evaluate and respect her wishes at all possible, take into consideration her values, her beliefs, her autonomy, take into consideration her input, as well as any prior communications that were written before we became the guardian, which means that if Jennifer had already completed an advance directive, we don't change that as the guardian. If Jennifer says, I made myself a DNR, we don't change that. If Jennifer says, I want to be cremated, we don't change that as her guardian. Next slide, Jennifer. So what are some of the roles that the case managers perform? You've already heard me talk about assisting with obtaining living arrangements. We will try to put every services in place to allow Jennifer to remain in her home as long as possible. And we did. She lasted for another 6 months. Even though Ashley disagreed with us, the case management and the guardianship was not about Ashley. It was all about Jennifer. And I say that because we have a lot of families expect that guardianship is obtained, the state becomes the guardian in order to the state to follow their wishes. It's not about the family. It's all about the client and their wishes and desires if they're able to communicate. If not, then we have to determine what the client would have wanted if they were able to communicate. And we take it from that standpoint. But just to say, for instance, hate to make you the bad person, Ashley, on this, but just to say, if Ashley thought that by not getting guardianship and allowing the state to become the guardianship, that she could sell Jennifer's home and take the proceeds, that didn't happen. Because even though we were Jennifer's guardian, we allowed Jennifer to stay in the home. We can go back now to the court. And because Jennifer owned her own home and we have to place Jennifer somewhere, that home needs to be sold in order to have more assets to assist Jennifer with where she's being placed. So now we can go back and request the court for a conservator to be named, because that was something that Ashley did not do in her petition. Ashley only petitioned for a guardian to be named, not a conservator. We've been able to determine Jennifer has a car, Jennifer has a house, Jennifer may have, well, we know Jennifer worked for DHS. Jennifer has stock. She was never married. She lived alone. We can't allow Ashley to just come in and take everything that Jennifer has, even though some families think that they can do that. But we're making sure that Jennifer is protected, even if she leaves at home. We will go back and petition for the court to name a conservator. We also will help schedule and attend medical appointments when we can, including giving any consent for medical treatment, unless if Jennifer had a limited guardianship, like I stated earlier, where Jennifer maintained the right to make her own medical decisions without the state involvement. We also would arrange for any transportation that Jennifer needs, as well as ensuring her needs are met when we place her in a licensed personal care home or a nursing home or assisted living. We will also, with her living in her home, explore and secure needed resources. Can we get CCSP involved? Can we get homemaker services? Can we even reach out and tap into Allison's shop for resources to see if we can put it in home services for? And we will also work with providers and other stakeholders on Jennifer's behalf. We were able to get Jennifer into substance abuse treatment, and she's doing well. But because I aged Jennifer, as she continued to get older, Jennifer started having situations and instances in her home where she was becoming more forgetful and falling. So we had to look at moving Jennifer out of the home. Next slide, Jennifer. Now, what we cannot do to a client as the case manager and representative for the department who serves as guardian, we cannot involuntarily commit someone. We cannot approve for someone to be physically controlled or put in restraints. And this is a big one that a lot of people call and say, well, can't you get guardianship to help them with their drug and alcohol abuse? No, we just can't go and become the guardian for someone who has a chronic alcohol or drug abuse. That's not going to stop them. The only reason we were able to get Jennifer involved in a substance abuse treatment center was because we became a guardian under the petition that was filed with her having Alzheimer's and dementia and living alone. But just to say we can go and become the guardian for someone who is a chronic drug user or a chronic alcohol abuser, no, we can't do that. And even when we're the guardian, we cannot force and make them to stop using drugs or abusing alcohol. We can't even, as Jennifer's case manager and representative for the department, we can't even control who she communicates or visit with. Now, Jennifer has a best friend that Ashley always resented and hated when they were growing up, who is by the name of Chloe Brinkley. Chloe always was a bad influence in persuading Jennifer as a teen growing up to stay into trouble. And Ashley did not like it because Jennifer was giving their parents fits. So Chloe has come back into the picture. Ashley finds out and says, by no means do I want Jennifer having any contact with Chloe. Can I stop that? Can a case manager stop that? No. The only way that does not occur if Jennifer herself can say, I do not want to have any type of communications or any type of visits with Chloe. Jennifer can even say, I am sick of my sister. My sister has ruined my life. I do not want to have visits with Ashley. If Ashley gets wind of that and call us and say, well, my sister don't want to have visits with me, you all need to allow her to have visits, we can't force her. We cannot force her. We can't even change perceived bad behavior as a guardian. We can't say one has to be put in a locked facility as a placement. And this is a big one. We can't even force medications or nutrients. And I added nutrients because years ago, we got a petition for an emergency appointment of a proposed ward who was in jail. And the jail filed a petition basically because the man was on a hunger strike. And they felt that the individual needed to eat, and they wanted a guardian appointed to force him to eat. Well, remember, you heard me say we can't force anyone to do anything. Luckily, we were not appointed that guardian for the simple reason the day of the hearing, the doctor, it came out doing testimony that the doctor who signed the affidavit had never laid eyes on that individual. And the individual testified that himself, and it was confirmed by the nurse. And it came out that the nurse actually completed the affidavit and the doctor just signed it. And that was a no-no for the court. Well, it also came out that the individual said he had been in jail for a long time. He wanted to be processed. Either you're going to have me a hearing or release me. And that's why he went on that hunger strike. So we were fortunate to get out of that one, but we cannot force medications or nutrients. We can just encourage individuals who saying, I'm not going to take this medication. We can only encourage them to take the medication. Next slide, Jennifer. So things that I want you to remember today: DHS is appointed guardian. Remember I said not Carl, not public guardianship office, not the assigned case manager. Only the department is appointed the guardian. PGO and the assigned case manager are representatives of the department. And guardianship is all about the client and his or her best interest. Not, as I stated earlier, not the desires of Ashley, who was Jennifer's family member, or community. We have a lot of individuals in the community that feel this person needs a guardian so you can put them somewhere. This person needs a guardian so you can make them do something. Guardianship is not all about putting someone somewhere, forcing someone to do something, because even though the courts has indicated the person lacks the capacity and has removed rights, the individual still have rights. And if we violate those individual rights, we can be sued as a violation of violating those rights, not taking into consideration the person's needs, the person's desires and wishes. Now, you've heard me talk about guardianship on what we do doing once we would become a guardian. I don't have it on my presentation, and I think we're almost to the end. But one thing I would like to say to you is that we just don't get guardianship to keep it until the person dies. We try to find someone else to become the successor guardian, because one thing that I try to stress to families or individuals who are involved with clients is that it's much more easier for someone else to step up and serve as the guardian than the state, because it's not going to happen right then and there when something needs to be done, because as you know, the state has guidelines and policies that has to be followed. Even with the public guardianship office program, we have to follow policy and guidelines to even give consent for treatment. So it's not going to be something that can happen right then and there. Well, we also want to make sure that a person is as independent as possible. And sometimes that independence includes going back to court and restoring an individual's rights. So yes, that can happen. We as representatives of the department can petition the court to have their rights, a person's rights restored. And in this case, Jennifer was placed in a nursing home, went through her substance abuse treatment. Come to find out, she was misdiagnosed. Jennifer doesn't have Alzheimer's and dementia. Jennifer was just letting her substance abuse take over. Jennifer went to a nursing home, improved so much. We didn't know that when she was in the home, because we're not in the home 24/7. Jennifer was still turning up that cup that we saw her turn up early when Allison was presenting. But when Jennifer went to that nursing home, Jennifer's health improved. Jennifer became much more alert. She pushed Ashley out of the picture, and the social worker contacts us and say, hey, I don't think she needs to be here. Then if that's the case, we will go out, assess Jennifer, and if we determine that Jennifer can have her rights restored, the department will file a petition for restoration to allow it to go through the process again in the court, where she will also have to have another evaluation. There will also have to be a hearing, and at the close of all facts presented and evidence, the judge will make a decision as to whether or not Jennifer can have her rights restored. We try to do that for all our individuals, because there may be certain instances or situations that will occur to make someone be in need at that moment of a guardian. But during the life of that case, everything improves to the point that that individual no longer needs a guardian, and it's only fair for them to try to have that opportunity to get their rights restored. Next slide, Jennifer. This is my contact information. If you ever need to reach me, I would say the best way to reach me, because I am constantly on the road so much, is to reach me by my cell phone. And that is my presentation for guardianship. Any questions?